call the member for Wallandilly.
Thank you, Madam Speaker. Madam Speaker, I'm very pleased to speak in support of the Residential Parks Amendment Register Bill 2011. I applaud the Honourable Minister for Fair Trading for his diligence and hard work in his portfolio. In presenting this bill, he has made the all-important first steps in delivering on the government's commitment to review and reform the residential park sector. Madam Speaker, as we've already heard, this bill will enable the creation of a register of all residential parks across the state, allowing the government to identify exactly where these parks are located and who the operators are. I know in my own electorate of Wallandilly we have such parks such as the Avon Caravan Village, located at the beautiful Bargo, and many others, as well as the many destinations to visit. Madam Speaker, I'd like to now highlight how important this bill is, not just to the park operators, but also to the many people who live in residential parks in different areas across New South Wales. As the Honourable Member for Terrigal said earlier, many people in New South Wales have made a lifestyle choice to live in a residential park. This is particularly so in rural and regional areas where parks are seen as an affordable housing option. However, residential parks are quite different inland compared to those in coastal areas. The same may be said of the types of occupants who live in them and their reasons for doing so. Speaker, I recently came across a report titled Getting to Residents of Inland Parks, produced by the Parks and Village Service, better known as PAVS, in association with the Gunya Aboriginal Tenancy Advice Service. Although the report was published back in 2001, its contents are still relevant today in highlighting the many differences between residents of coastal areas and inland parks. The report found that people living in inland parks were quite different to residents in coastal parks, who are mainly retirees or older people who own their own dwelling and rent the site in the park. And Speaker, for many people in inland parks, park living is not a lifestyle choice or retirement haven. They simply have no alternative, as they cannot access other types of rental accommodation. Many inland park residents don't own their own dwelling, but rent it from the park operator. They often comprise casual, itinerant workers, people on low incomes or Centrelink benefits, and sometimes, unfortunately, with people with mental health issues. Many inland park residents have been unable to sustain tenancies elsewhere and cannot find a house to rent. In other words, Madam Speaker, many residents of inland residential parks have simply no other housing option. The PAVS report found that inland park residents stay for a relatively short time when compared to residents of coastal parks. Only 35% of residents had lived on their present park for more than 12 months. Coastal parks are predominantly occupied by retirees over 60 years of age, and inland parks are mostly occupied by people in their 30s and 40s. Madam Speaker, the study also found that there were no resident advocacy groups for inland parks compared to the many active resident associations in parks in coastal areas. This makes consultation difficult and means there is no network to support education initiatives. I know this firsthand, Madam Speaker, because in a former life, for a period of time, I worked for the Western Sydney Tenant Service, and on a very much ad hoc basis represented people in these residential parks and know some of the problems that they went through. I also know that the PAVS provide an excellent resource, and it provides training, resources, advocacy and information on the rights and responsibility of residential parks and manufactured home and estate residents. PAVS receives and addresses inquiries on all aspects of residential park tenancies. All of its services are provided free and include casework support and referral, training and resource for tenants, advice and advocacy services and other organisations throughout New South Wales, community education and resources for residents of residential parks throughout New South Wales, advice on legislation, and the PAVS team, of course, provides paralegal services, but it doesn't include the legal services, and input into policy that affects residential parks. PAVS facilitates the New South Wales Residential Parks Forum and the Parks Legal Working Group and is an active member of many policy committees, including Residential Parks Operation Committee, or the Consumer Trading and Tenancy Tribunal, Utilities Consumer Advocacy Group, Tenancy Legal Working Party. PAVS also produces many other documents to support residents and their newsletters, and I encourage residents to speak to PAVS for further information. Madam Speaker, around half of the known residential parks are west of the Great Divide, yet very little is known of them. Few residents or operators of inland parks contact Fair Trading for advice on their rights and responsibilities. Even fewer take disputes to the Consumer Trader and Tenancy Tribunal. It is unclear whether this means that the inland parks are so well run that there's little need for residents and owners to seek outside help or advice, or whether there's other issues at play. Madam Speaker, it's important that the views of inland parks be heard, and the register will provide an opportunity for the government to identify and consult with people living in residential parks in inland areas of New South Wales. This will enable a more comprehensive review of the legislation than has ever been undertaken. It's important to firstly find out where the inland park residents and owners are, to let them know that the government is doing a review and to hear about what issues are important to them. Madam Speaker, registration of the inland parks will provide a channel for a two-way flow of information and will allow the government to target information where it is needed by providing information more directly to residents and operators. The register will be an extremely useful tool to identify the location of all residential parks and ensure that the government consults with park residents and owners across New South Wales, not just those along our coastline that have dominated previous reviews. And just very briefly, I just want to go through some of the new proposed sections of the Act. Section 142A, Madam Speaker, gives the Director-General of the Department of Finance and Services the power to require a park owner or park manager to provide registrable information about the residential park within the period specified in the notice. Madam Speaker, failure to comply with this requirement attracts a maximum penalty of 5 penalty units. Also, of course, is Section 142B, which imposes an obligation on the park owner to give the Director-General notice of a registrable event within 30 days of the park owner becoming aware that an event has occurred. And failure to comply with this requirement also attracts a 5 penalty units. Events with constituent registrable events include a change in the trading name of a park, a change in the park owner or manager, the closure or opening of a park, or a significant change in the number of sites in the residential park used for permanent occupancy. Section 142C prohibits a person from providing false or misleading information. Section 142D requires the Director-General to establish and maintain a register of residential parks in which the Director-General must enter all the information provided to the Director-General under the proposed part. The trading name, address and contact details for residential parks may be made available to the public for inspection. Madam Speaker, this bill is an essential starting point to improve the framework and governance of all residential parks, and I commend the bill to the House.
Madam Speaker.
Question is that this bill be now introduced.